Good morning. Today is Thursday, June 18th, 2026, and welcome to today's regular meeting of the California Fair Political Practices Commission. Ms. Vo, will you please take roll?
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Here.
Chair Silver?
Here. Excellent. Well, let's start with item number 1 on our agenda, and that's public comment for items not on today's agenda. Do we have any public comment for items not on today's agenda? Looks like we have some in the room. Please come up. Good morning. Yeah, if the green light's not showing, you just press the button next to it.
Great, good morning. In the Father, and the Son, and the Holy Spirit, amen. Santa Misa Virgen de Guadalupe, patrona de las Américas, tu persona en Tepeyac, en la versión de los pueblos del continente americano. De ti nació nuestra libertad y salvación Jesucristo, que rompió para nosotros las cadenas del pecado y de la muerte, y nos traes las promesas de la vida eterna. Amén. I am the defender of San Joaquin County's children, elderly, families, and friends. My government-issued ID is B9878294, and my legal name is Lauren Danielle Elias Cardinali. I'm a 9th-generation California from the De Anza expedition. I would like to first thank the FPCC Enforcement Division for their reasonable assessment of my acquired disability during my run for politics, and not rendering me fines due to my impairment that was caused by a failure to perform, protect, and serve by multiple local enforcement agencies. Thank you to Stephen, Christian, and Mr. Cornwell. Upon my initial submission of filing paperwork, I have been subject to acts of civil harassment, including male domestic violence, including violent outbursts and intimidation to chill my speech, by private citizens and former public servants. I have been granted a 5-year restraining order thanks to my counsel out of Lodi and the Lodi court system. The destructive effects of domestic terror against my person, my children at their schools, and at my place of employment with a broken window have caused multiple impairments and disabilities to my condition that have made it unfair for me to run. The undue stress has resulted in over 20 pounds of weight loss, constant chronic nerve pain, an ulcer, a herniated stomach. On April 11th, 2026, at approximately 8 p.m., when the restrained defendant was in the room with me, my life was threatened via an Instagram message and post to my private message. I was standing in the room with the Senators Ted Cruz, the gubernatorial candidates Steve Helton and Chad Bianco, and the entire Cal GOP convention, and most importantly, 3 of my younger children were with me at the San Diego Sheraton Harbor Boulevard, and including Mr. Happy Singh, the congressional candidate against Josh Harder. More than 30 incident reports have been made to the affected local enforcement agency jurisdictions, including police, sheriff. 5 no responses from FBI, the Texas Rangers, the U.S. Capitol Police, and the Attorney General of the state of California, Rob Bonta, gave me a Post-it note and told me to come back in 3 weeks. I am here today to humbly request support from the FPCC to investigate Cardinali versus San Joaquin County. In the initial phases of my run, the county posted an Instagram message that came directly from the incumbent Paul Canepa on Women's Day, saying it was directly from him. In our ballot measure—
My apologies for interrupting you. I just want to clarify, to avoid us being biased or prejudiced as to any subsequent complaint that you might file. We don't want to discuss the substance or facts of any complaint that you're planning on filing with the Enforcement Commission. So what I'd recommend is, if you believe that there's been a violation of the state's ethics rules that fall under our jurisdiction, I would reach out to our Enforcement Division and file a complaint so we can go through the process. But thank you so much for coming today.
Thank you for that, and I reclaim my time. How much time is left, Ms. Davina? The minimum expectation of the county, state, country, and city rules is that my family is protected and free from inherently dangerous conditions while in public at all times, as well as being a citizen of the United States. I am to be provided under the state of California, federal laws, and the Constitution, the common law protection of maintaining my freedoms.
Thank you for your comment. Do we have any additional public comment in the room today? Do we have any online, Ms. Vo? Okay. Let's move on to item number 2, and that's going to be approval of our May 2026 meeting minutes. Commissioners, any questions, comments, thoughts on the minutes? Do we have any public comment on the May minutes? Hearing
Motion.
and seeing none? Well, go ahead.
Motion to approve the May 2026 Commission meeting minutes.
Second?
Ms. Vo?
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Chair Silver?
Aye.
Motion passes.
Excellent. Let's move on to our consent calendar. And that's going to be items 3 through 7 today. Are there any items on the consent calendar that commissioners wish to discuss or pull from the consent calendar? I don't have any. Commissioners? No? Do we have any public comment for items that are on the consent calendar? No? Okay, then I will make a motion to approve the consent calendar. Do I have a second?
Second?
Okay, Ms. Vo?
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Chair Silver?
Aye.
Motion passes.
Excellent. Let's move on to items 8 and 9. Up at the desk, we'll have our Chief of Enforcement, Kendall Bonebrake. Good morning, Chief Bonebrake.
Good morning, Chair, Commissioners. Thank you for having me today. I do want to, before we get started, let you know that item number 9 is being pulled today, as we have heard from the respondent in that case and are working with the respondent at this time. If it needs to come back to the Commission, it will at a later date, but not today. So we're only proceeding with number 8, South Bay.
Okay. Any questions or comments from commissioners regarding item number 8?
Nope.
Commissioner Wilson?
It's more of a question, and I know this has been explained in the past for the benefit of the public. Could you just briefly explain why the proposed penalty, which I'm not questioning, is $56,500?
Absolutely. If you take a look, the commission does look at several different factors when determining the penalty that are set forth in Regulation 18361.5. One of those that is fully explained in the default is comparable cases. And those comparable cases, if you look at the back of the default, are proposed, generally speaking, per count or per type of count. And so I'm just trying to find it quickly so that I can point you to exactly where that is. We have gone through count by count and proposed comparables, given you information with regard to those comparables and whether or not there are aggravating or mitigating circumstances, and then from there provided the penalty that we would recommend.
Yeah, thank you. I think the information that's available to the public was very detailed, but because of the amount, I appreciate the explanation. Thank you.
Absolutely.
Do we have any public comment on item 8? No. Hearing and seeing none, I'm going to move to approve item 8.
Second.
Ms. Vo?
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Chair Silver?
Aye.
Motion passes.
Excellent. Thank you, Ms. Bonebrake. Let's move on to our general items 10 through 15. Let's start with number 10, and that's going to be a motion to vacate default decision and order in the matter of committee to elect Stevana Evans, 2018 Adelanto City Council, Stevana Evans for Board of Supervisors, 2020, and Stevana Evans, FPPC number 201097. I believe our general counsel will be walking us through this item. Good morning, Mr. Bainbridge.
Good morning, Dave Bainbridge, General Counsel. I'm going to provide a little procedural background on this matter, and then the parties will have an opportunity to speak on it. We have a motion to vacate a default decision that was approved by the Commission back in March. The respondent in this case was served with an accusation last June 2025, did not file a notice of defense. Through its normal process, the Commission ended up adopting the default back in March. Subsequently, the respondent in the case filed a motion to vacate in late April. The motion to vacate is to eliminate the adoption of the default decision and would essentially put the enforcement case back in a place where it could go to a hearing. The motion to vacate was filed technically late. It's 7 days from the date that the motion to vacate is served on the respondent that they have to file the motion. However, we're bringing it before the commission in the event they have the authority to make a decision and waive the fact that it was late and still make a decision on the merits if the commission so chooses. So the standard for considering a motion to vacate is provided by statute in the APA. The two grounds on which the commission could grant the motion to vacate, which would take away the default order, is that there was inadequate service of the accusation. And then the other grounds is that there was mistake, inadvertence, surprise, or excusable neglect for not filing a notice of defense. The merits of the case itself are not at issue here. The question is about service and fair notice to the respondent about participating in the process. That's necessarily the case because there hasn't been an evidentiary hearing on the merits. So there's no record of an evidentiary hearing for the commission to look at. So the commission is focused on whether they believe there's grounds to vacate the default decision that they adopted back in March. So that's the background. The commission, if the commission takes no action on this matter, it will be status quo. The default decision and order will remain in place. And then the majority of the commission would have to approve the motion to vacate. If that happens, then it will go back to enforcement. And the respondent has submitted a notice of defense in the event that the motion to vacate is granted. So it would be moving forward with an administrative hearing, presumably. So that's the background. If you have any procedural questions, otherwise, I think the parties are available to provide some information if they'd like.
Excellent. Thank you, Mr. Bainbridge. Is the party making the motion planning to present any information or arguments? Okay, excellent. Any questions from commissioners before we go ahead and have them speak?
Oh, the Ms. Evans rep is here?
Correct.
Okay.
Yeah, okay, we'll let them go. Go ahead, good morning. Good morning, can you hear us?
Yes, good morning. Good morning, Chair and Commissioners. Thank you so much for your time today. As Mr. Bainbridge had stipulated, this is a motion. We brought it under the California Government Code 115220, which gives you all, the Commission, the discretion to vacate a default decision upon a showing of good cause. And we respectfully submit that good cause exists here and that the matter should be resolved on the merits. In the motion to vacate that we submitted to this commission, to this body, we stipulate that our client, Ms. Evans' failure to timely respond occurred against a backdrop of serious personal, medical, and family hardships, including cancer treatment, surgery, recovery, domestic instability, and disruptions with COVID-19. This is for some of the violations that were stipulated within the notice of default. And so with these circumstances, they really help explain the failure to respond and show. I want to be clear that the default was never a tactical decision to evade process. Since the notice, our client has made considerable effort to substantially comply with all of the things that the Enforcement Division found within its notice and has retained counsel. We were retained in at the end-ish of April, and so we are working with our client to make sure that we have all of the documents and things stipulated. We would really like the opportunity to be able to take this to a hearing on the merits rather than it be a procedural default. So I know that in the response, the Enforcement Division pointed out an early email to suggest that our client did not intend to file notice of a defense. But again, that statement was made more before they retained counsel and before she had a full understanding of the consequences of default. And so we believe it should not foreclose relief where the present record shows participation, corrective action, and a request to be heard. We believe that to be able to comply, that is the whole point of this process that we're going through, is to make sure that this act is enforced and that that this act is enforced, and that is what we are ensuring that is happening. It is so for the intent of the commission, we just are asking now that we be granted respectfully the request that the motion be vacated.
Thank you. Does our enforcement division have a response, kind of a summary of their brief that they'd like to share? Sounds like we do. We have our chief enforcement, Bone Break, coming to the table here. Good morning.
Good morning again, Chair Silver, Commissioners. I believe that the Enforcement Division's response is thorough and provides a complete summary of our stance. But what I just want to point out, which I think is the crux of this, is the fact that the question here is whether or not the failure to timely respond to the accusation was the result of mistake, inadvertence, surprise, or excusable neglect. Here, our response provides an email from the petitioner in this motion that clearly states that she read the accusation packet, and made the decision not to respond. And therefore, given those facts, we would ask that the petitioner's motion not be granted today. But I'm happy to answer any questions if you have them.
You could remain at the desk. If you could remain at the desk, just in case commissioners have any questions. Commissioner Ortiz?
Thank you, Chair. I am trying to understand the showing of good cause as Ms. Evans is claiming here. In the memorandum of points of authority, her lawyer states that because of the pandemic, it altered daily life, limiting her access to resources and reducing her ability to communicate. However, the COVID ran between 20 and 23. During those years, she ran for board of supervisor and she ran for mayor. So I assume that when somebody is doing a campaign, that they're going to be sending out communications, they're going to have an endorsement. So there was an active life during COVID running for another office. Then she had some health problems, I'm sorry, in June 21st, but she ran for mayor in May 22nd. Again, she had to run a campaign, which involved reaching out and very active campaign activities. In 2024, she ran for city council again, and despite of the tumultuous personal life that she had, again, she had an active and I assume responsible campaign. She admitted, as you mentioned, to receiving the accusation and chose not to respond. I am lost in understanding why a good cause argument will be valid in this situation. She had tons of referrals, never answer. To me, this is not negligence. This is not, because of health or COVID. This was an affirmative reaction from her.
Ms. Evans, counsel, I don't know if you have any response, or we should move on. Okay.
Yes, thank you so much. So what you are stipulating, I think that really hits on the fact of what we're saying is that this should be found upon the merits and the motion should be vacated. There were a lot of things that were happening to our client during that time, and I think that it would better serve the public interest, we believe, and also in align with what the commission in being able to hear all of the facts and to be able to make a determination on the merits of the case. During this time, our client was dealing with a lot of mental health issues, some domestic violence, a really messy divorce, and cancer. And so that being stipulated with some of these notices and the things that you pointed out, some of the things fell through the cracks. And so because there are things that you have pointed out, and it is a bit complicated, we believe that granting this motion would not prejudice enforcement. The division would remain free to prove every allegation of the violation, and the commission would remain free to impose whatever sanction the evidence supports. So vacating the default would simply ensure that the matter is resolved after a full presentation of facts rather than solely through procedural default. We have a narrow scope to just remove the default judgment as opposed to the facts that underlay and the appropriate. And so even the amount coming to over $70,000 is a considerable amount. And because of the amount that we are looking at, we do believe in fairness to allow our client to be able to make a full presentation of the facts would be aligned with the commission's intent to ensure that all politicians are reporting their incomes, turning in their statements, and complying, in which since the default, as I mentioned before, our client has been complying and has now retained counsel.
Thank you. Just to confirm, we're not considering whether the decision today will quote unquote prejudice enforcement in any way, correct?
No.
Okay, that's helpful. So, but as that issue just brought up generally, I have some background that I would like to share about my perspective on this. So, one thing we haven't talked about today is the hours and hours and hours that it takes our enforcement team to work up a case to this point, to litigate a case like this, where you have a respondent who ignores communications, official communications from a state agency. And that includes the FPPC as well as the local filing officials, campaign officials that Commissioner Ortiz referred to. It's my understanding that the respondent was personally served twice. Is that correct, Ms. Bonebrake?
So personally served prior to the defaults with the accusation at City Hall.
Okay.
But that was the one time prior to when she was personally served. So yes.
Okay.
And then the default was then later served, but that was after the commission entered the default.
Okay, so they were personally served, and as with any stipulation or default, there's a description of the types of liability that you could potentially be liable for a violation of the Political Reform Act in that paperwork, correct?
So just to be clear, she was personally served with the accusation, which does set forth all of the all of the counts. Then later served via mail with a pre-notice default, which is the opportunity prior to the actual default, giving the information. And then the final default paperwork setting forth all of the information, including the penalty information, was also provided via mail.
Okay. So the point that I'm getting to is I find it offensive to a certain extent that we're asking our hardworking team in a campaign year to put even more resources towards a case where I feel like the respondent has gone far beyond excusable negligence in terms of responding to communications from the FPPC and the way they've conducted themselves as a candidate in this manner. That's where I'm coming from. I have not seen any evidence that meets this standard of mistake, inadvertence, surprise, or excusable neglect. Certainly, it appears that proper service has been provided. I don't think anybody's arguing that it hasn't. So I don't see that either one of the criteria has been met to approve this motion. But I'm open to additional comment and questions from commissioners. Do we have any additional?
Agree.
Okay, is there anything that you want to say in closing, Ms. Bonebrake?
Nothing further. Thank you, Chair and Commissioners.
Thank you. Anything closing from council?
I do, yes. I just would like to say that the commission will have the ability to ensure accountability on the issues and on the merits, the facts. All this would allow is just our client to be able to explain, but it does not remove accountability. And we understand the seriousness of this situation. Our client does too, which is why they retained us. We're not arguing about serving, we're arguing about excusable neglect and allowing our client to still continue to be held accountable, but allow them to be able to explain.
Thank you. Do we have any public comment outside of the parties? No? Okay, we do not have to make a motion to deny. However, I think it's worth just being clear on the record as to where we stand. So I'm gonna make a motion to deny this motion. Do I have a second?
Second,
Okay, Ms. Vo?
Commissioner Ortiz?
yes.
Commissioner Wilson?
Aye.
Chair Silver?
Aye.
Motion passes.
Okay, let's move on to, thank you, Ms. Bumbrick. And thank you, Mr. Bainbridge. Let's move on to item 11. That's going to be a pre-notice discussion of proposed amendments to regulations 18360.1 through 18360.3, political reform education program and streamlined resolution program for low-level enforcement violations. And we have presenting to us Commission Counsel Simon Russell. Good morning, Mr. Russell.
Good morning. Can you hear me?
Yes, we can.
Thank you very much. I'm coming before you today for a pre-notice discussion of proposed amendments to our regulations governing what we call the PrEP and Streamline programs, specifically regulations 18360.1 through 18360.3. Because it's a pre-notice item, you won't be voting on anything today, but we're hoping to get your feedback on these proposals, as well as feedback from anyone in the general public or the regulated community who might be interested. I want to begin, logically enough, with a brief reminder of what the PrEP and Streamline programs are. These are enforcement programs. Their purpose is to efficiently resolve low-level violations of the Act so that staff resources are freed up for more serious and more complex cases. When I say low-level, I mean things like failing to file a campaign finance report that didn't have a large amount of activity to report, or receiving a gift that was slightly above the gift limit, things like that.
So essentially low public harm.
Correct.
Okay.
Specifically, these regulations provide two ways of resolving cases like this. The first is what we call PrEP. It's an acronym. It stands for Political Reform Education Program. And like the name implies, it allows respondents in low-level cases to take an educational course online instead of paying a fine. You can think of it basically as like the FPPC equivalent to traffic school. It's generally available to respondents who've committed a very low-level violation of a particular section of the Act for the first time. The other program in these regulations is the Streamline program. Now, unlike PrEP, respondents in the Streamline program do pay a fine, but it's generally a much lower fine than they would incur in a mainline case. And also, the stipulation in a Streamline case does not include a lengthy narrative of the facts like you might find in a mainline case. Instead, there's usually just a table listing basic information about the respondent and the violation they committed, like, for example, a list of all the forms they may have failed to file on time. Streamline cases are broken into Tier 1 cases and Tier 2. Tier 1 cases are cases where there are some significant mitigating factors, so the penalty is lower. Tier 2 cases are cases where there may be some aggravating factors, so the penalty is a bit higher, but still lower than what they would receive in a mainline case. In terms of procedure, there is a major difference between Streamline and mainline cases. Streamline cases do not go before the Commission for a vote. This is because the Commission has delegated the authority to approve Streamline settlements directly to the enforcement chief. The chief does include a list of all the proposed Streamline settlements in her monthly report to you, and you do have the ability to let the chief know if you object to any of the proposed settlements, but ultimately she does have the authority to execute those agreements. The idea behind this delegation is that when drafting these Streamline regulations, the Commission came up with very strict eligibility criteria for all the different kinds of violations. So in essence, you can think of it as if a case meets these eligibility criteria, then it's basically been pre-approved. So that's why we use this delegation method. And also because by following these procedures, these relatively streamlined and straightforward procedures, it frees up staff resources to focus on more complex and more serious cases. And also it means that a lot of these low-level cases don't make their way onto your agenda for you to have to consider either. The PrEP and Streamline programs themselves
Can
are...
I ask a
okay.
question?
Yes.
Commissioner Ortiz?
Thank you. The previous one you said approved by the chief of enforcement. Does the executive director gets involved at all?
This is actually an issue I'm going to be directly talking about because we are proposing to have the
Okay.
executive director get involved in some cases.
I mean, Lone Ranger out there.
But to briefly answer your question, no, I mean, the chief might confer with the ED on a case, but nothing requires the chief to do that under the regulations as they're currently written. The chief has the authority to enter these streamlined settlements on their own authority.
Commissioner Wilson?
Kind of a related question. I think Commissioner Ortiz was looking over my notes. That's okay, but it's a great question. But on a serious note, though, I'm looking forward to how you would explain that while I'm sure the chief of enforcement is going to make the kind of decisions that we kind of all have consensus on, at some point, I think it would be helpful to explain why the executive director doesn't have a role and why the decision by the chief of enforcement, even though we might be likely to agree, why that's a unilateral decision that is binding to the commission. I mean, I know that we've granted that authority, but we also have the authority, if you look at just basic procedure, to rescind it as well. So I'm not saying that that's something I would recommend, but I appreciate you laying out the various options. If there was a disagreement, let's say the chief of enforcement comes down with a decision and the executive director doesn't agree, what kind of options are available? And I'm thinking more just long-term, not necessarily in the short term.
I think a good place to, sorry.
Commissioner Ortiz?
Thank you. Commissioner Wilson said, does the executive director, and I know you're going to talk about it, reviews it? Or does she, well, she's in this case, have any role on this?
Yeah, and also, just a follow-up question. These settlements that are approved by the enforcement chief, they're not on our agenda for consideration, but they are a part of the agenda for the commission?
Yes, they're
You
in.
can touch on that after you touch on
Okay.
Yeah, I just want to make that clear to the public.
Nothing personal against you, Chief Enforcement.
I was going to go into a little bit more detail on this later, but I can also do it now. So the way the regulations are written right now, the ones that are in effect right now, they don't provide a role for the executive director formally to weigh in and kind of provide a second vote on any of these cases. Ultimately, the decision whether to enter into a PrEP agreement or into a streamlined settlement is with the chief. Now, the chief is free to discuss these cases with the executive director. I don't want to speak for the chief or the executive director right now. Maybe if they want to shed some light on what their sort of practices, they can do that. But as far as the regulations go, they don't currently contemplate the ED having a formal role in determining the outcome of these cases.
Sure, I'd love to chime in. Galena West, Executive Director. So although the regulations don't formally require it, since Chief Bonebreak started, the procedure that we put in place internally is that any use of discretion is sent to me for approval so that we can talk it out and make sure that we're on the same page. And likely one of the reasons we did that was to make sure that we're actually all on the same page and we're thinking about things and we're making sure that we all agree on what fits into Streamline and what doesn't, as part of not only her training, but also because this issue has been brought up by the commission in the past. So it was an internal procedure that we put into place. And then for a little background, I was chief of enforcement when the discretion was given to the chief. The chief of enforcement did not ask for this discretion, speaking of myself as a third person. But what happened was the commission had very lengthy agendas back in the day, and the meetings would go, 7 hours, 8 hours long. And it was because every streamline case was also on the agenda and considered. And so as chief of enforcement, I had to prepare all of those cases, and the commission asked questions about all of them and approved them. And so after a while, the commission started to get some really good confidence and faith in the streamline program as written, especially when we put it into a regulation. And they felt like since it was specific enough that that could be a delegated ability, and that the chief of enforcement would be following those rules. So that's kind of just a little background on how we got to where we are.
Thank you.
To follow up on something that E.D. West was saying in response to your particular question, Commissioner Wilson, another reason that this delegation was made to the enforcement chief is precisely because these regulations are quite granular in specifying how a case qualifies for streamline or PrEP in the first place. There's some pretty rigorous criteria they have to meet, and these are pretty low-level cases. So if a case does meet the criteria that are outlined in these regulations, which are quite detailed, the idea is it's a pretty straightforward case, so there really wouldn't be much room for a difference of opinion, with an asterisk, cases that involve the use of discretion. Now, that's an issue that I was going to specifically talk about a bit later in this presentation, because we are actually proposing to add the executive director as kind of a second vote, if you will, on approving cases involving the use of discretion. Chair Silver, to get to your question, yes, every month the enforcement division submits a report to the commission, and included in that report is a list of all the proposed streamline settlements. And at that point, the commission does have the ability, and they have not been executed yet, so the commission has the ability, if they want to flag one of those and say, I don't know, is this one appropriate for streamline or not? Let's talk about it. You can do that. And the chief can take that under consideration before she approves the agreements.
Thank you. You can go ahead.
Just to move on to how these regulations are structured, the programs are found in regulations 18.360.1, 18.360.2, and 18.360.3. The first two of these lay out the procedural requirements and the eligibility criteria for all the different kinds of violations that are eligible. They start out with general eligibility criteria that apply to all streamline or PrEP cases. So, for example, the violation must have resulted in a low level of public harm. There can't be any evidence that the respondent intentionally violated the act, and similar requirements to those. Once a case satisfies those general eligibility requirements, we then move on to the later sections of these regulations, which list the specific types of violations that are eligible. And under those sections, there are further eligibility criteria specific to each kind of violation. So, for example, say you have a case involving a committee that received cash contributions over $100. So first of all, the case has to qualify under those general eligibility criteria. So has to be a low level of public harm. In other words, can't have been a very large amount of cash. The respondent cannot have received this cash intentionally. Once you've satisfied those general eligibility criteria, you then move further down the reg and you find the section dealing with cash contribution violations. And you look at the specific eligibility criteria there for that kind of violation. And you'll see that in order to qualify for PrEP or Tier 1, the cash has to have been timely reported on a campaign finance form. The total received must have been less than $5,000 or less than $10,000 in a Tier 2 case, and there can't be any evidence of personal use of the funds. Only once they've satisfied those criteria is the case eligible to be resolved under PrEP or streamline, depending on the dollar amount at issue. Once a case does qualify for streamline, we move on to Reg 18.360.3. That's the regulation that provides all the penalty ranges for both Tier 1 and Tier 2 for each kind of violation. We last updated these regulations in 2024, and because these regulations are quite lengthy and because they involve delegated authority, we conduct periodic assessments to see if there's any issues that have come up with the implementation that might require further revisions. And last year we did receive a request from the Commission itself to conduct such an assessment. So we did that, and what we found after conferring with the Enforcement Division is what you see on the slide in front of you. We identified some implementation issues, most of which are procedural in nature and have less to do with the specific eligibility criteria. Specifically, there are 5 main issues that we're trying to address in the proposed amendments in front of you today. I'll go into detail about each of these on subsequent slides, but just to quickly go over them, the 5 issues are, number 1, clearly spelling out which eligibility criteria in these regulations are mandatory versus advisory, defining the scope of discretion to include or exclude borderline cases from Streamline, making clear the conditions under which respondents have to fix the underlying violation before they can qualify for PrEP or Streamlines, what we call coming into compliance. Number 4, specifying what information actually needs to be included in a Streamline stipulation. And finally, clarifying the process for issuing warning letters, which is a separate process from Streamline and PrEP. Overall, I would say also a main issue that's not listed on this slide, but which underpins almost all of them, is just how long and complicated these regulations are. If possible, it would be ideal to simplify them, and we're trying to do that via these amendments, just to make them a bit more user-friendly. This is supposed to be a way to efficiently resolve cases, so it helps not to have regulations that are more complicated than they need to be. And then a secondary issue we identified when reviewing these regulations is we did find some elements within some of the eligibility criteria that we need to tweak or harmonize with changes in the law that have occurred in the last year or two. So I'll be going over those towards the end of this presentation, but the main focus of what I want to talk about are the procedural changes that we're proposing. The first of those, oh, by the way, if you looked over the actual draft of the changes that we're proposing, you might have been taken aback because it looks like a lot of red lines and strike-throughs. You might think that we're doing like a major overhaul of the program. That's not really the case. I'd say that most of the changes we're making are just in the nature of clarifying things that are a bit unclear or simplifying things. The core of the program is remaining the same under our proposals. I just want to make that clear in case you were kind of taken aback by how the proposals actually look. And that's definitely the case with the first change that we're proposing here. We did receive feedback from enforcement during this review that it was sometimes difficult to tell when they were applying these regulations of all the eligibility criteria that are listed in there, which ones are mandatory versus which ones are advisory. Because the way the regulations are written right now, they include terms like eligible or considerations or exclusions in ways it's not always clear to staff what these might mean in a particular instance or how they interact with each other. For example, enforcement has raised that it can be especially confusing when you're dealing with a case like, for example, say a campaign bank account case, where it lays out the criteria under which a case is quote unquote eligible for Streamline. And some of the criteria have to do with dollar thresholds. You cannot have spent a certain amount of money from a non-campaign bank account. Other criteria deal with a percentage. You cannot have spent a certain percentage of your campaign funds from a non-campaign bank account. And those two don't always line up in every case. Sometimes respondents will satisfy one of those but not the other, but it's a little unclear how enforcement is supposed to kind of weigh or treat these criteria when the only guidance they're given in the regulation itself is that cases are quote unquote eligible under these criteria. So what we're trying to do, it's pretty simple actually. We're just trying to use consistent terminology within these regulations. We're trying to say if an exclusion is meant to be mandatory, we're saying a violation is excluded if, and then the criteria laid out. If it's meant to be like a factor to weigh, what I'm calling advisory, then if we say, quote, it shall be a factor for consideration of possible inclusion if, and then we list the factors to consider. It sounds pretty simple, but it would really help to make these regulations a lot more user-friendly for enforcement. The second procedural change that we're proposing, and this is what we were talking about earlier, it relates to the use of discretion in borderline cases. These are cases that technically do not meet the eligibility criteria for PrEP or a particular Streamline tier, but where staff believes that there are significant mitigating factors present that weren't contemplated by the regulations that still argue for these cases to be included. Like, just to make it concrete, for example, in a case involving a late campaign finance report, a committee was late filing one of its reports, it's 460. There's an exclusion from Tier 1 under the regulations as they're written right now, saying that if the late report had more than $25,000 of contributions on it, then if we're dealing with a local committee, they are excluded from Tier 1 streamline. But say there are other factors present, like say that the amount over $25,000 is just a few $100s, or that it was only a week late, or the treasurer was sick, or some combination of the above. These are not actually listed or contemplated in the regulations right now, but these are the kinds of situations you can multiply these by any kind of factual situations you can think of that do come up in real cases. Basically, there's just no way to write regulations that will contemplate every single possible factual situation that could arise. So what the regulations—
Commissioner Ortiz?
Yeah.
If you can tell, I don't know if you know.
I don't know like a hard number off the top of my head. I would say that most of the violation types generally include at least one type of exclusion that's specific to that kind of violation. Not all of them. I'd say most of them do. I don't know the exact number. And then, of course, there's the general exclusions.
10, 5 exclusions or what?
I mean, again, part of the issue too is that, going back to my earlier slide, it's sometimes hard to tell what's meant to be a hard exclusion, what's not, but so it's a little hard for me to give you an exact number. I would
So
say—
sorry to interrupt,
Yeah.
in the proposed regulations, it
Yes.
seems like there's at least one exclusion for each violation type that is allowed to be resolved via streamline. Does that
Yeah,
sound
basically, yeah, that sounds right.
okay?
Yeah. I don't have it memorized like that. But yeah.
Sure. Yeah.
Okay.
So then essentially what we're doing here is we're creating an additional level of review, prophylactic, to make sure that if discretion is provided, that it's reviewed by the executive director. And then we, again, as the commission, will then take a look at these cases that are approved by the executive director per her discretion. And we can give feedback to the enforcement division, the executive director, as to whether we feel like the executive director is acting consistent with the guidance that we've provided. Is that kind of the process that we're looking at here to make sure that where discretion is provided, that it's done consistent with the intent of the commissioners and the commission?
That is correct, yes. We're actually trying to address two issues with this proposed change that's listed on the slide here. Because first of all, the regulations, when it comes to the issue of discretion, what they say right now is, quote, "The chief of enforcement will determine the appropriate form and amount of penalty to offer in settlement for a violation depending on the circumstances." It's unclear how this would apply if there is an exclusion in the case. Again, going back to my example of the campaign finance report that's slightly above 25,000, is that a hard exclusion, or does the chief under this language still have the ability to effectively override that exclusion and include the case anyway in Tier 1? You could argue it both ways under this language. So what we're proposing to do is, number one, make that clear. And number two, provide the additional safeguard that you described by getting the ED involved in decisions like this. So our proposed language says, quote, "The chief of enforcement will determine the appropriate form and amount of penalty to offer in settlement for a violation depending on the circumstances." That's the same as it's written right now. Here's the new language. "Unless an exclusion applies, in which case the executive director of the commission, after receipt of a recommendation by the chief of enforcement, will determine the appropriate form and amount of penalty." In other words, if discretion is being used, then the ED has to make the call. So that is essentially what you described.
And then we still have the opportunity, based on the process of disclosing these cases, to take a look at the cases ourselves. And if we believe that the discretion is being approved inconsistent with our intent, then we can provide that feedback. So just to confirm, so that that process can be effective, is there going to be some sort of notice provided to commissioners, the commission, as to when discretion is being used? And if that's not a question that is really in your scope, if the executive director or chief of enforcement might chime in on that?
Sure. So under our proposal as written right now, and we're just at pre-notice, we haven't included anything saying that any kind of notice or flag should be put in these stipulations or in the enforcement report telling you that discretion was used. That has been the practice in the past to do that. And I have a subsequent slide I was going to get to talking about our proposals for this regulation to say what information should be included in a streamlined stipulation. We could include in the regulation that in addition to the other information we're saying should be included, we should explicitly say if discretion is being used in this case, put it on the stipulation, put it in the enforcement report as well, whatever the commission thinks would be the best way to go about doing it. That has been the practice in the past, but we could very well write that into the regulation itself if the commission wants.
Yeah, my feeling is that we want to make it clear to us as commissioners and to the public where discretion is being used, the manner in which we do that or require it, enforce it. I'm open to what other commissioners want to do and what the executive director and staff recommend. So we can talk about that once that issue comes up. I just want to make sure we're clear as to what the levels of review would be here. So you'd have the enforcement chief reviewing the recommendation of staff, making sure everything's consistent with the streamline regulation. If ultimately they identify that an exclusion applies, if they wish to, they can go to the executive director and seek her approval for resolving that case via streamline, despite the fact that you have that exclusion there. And then we as a commission would then analyze each one of these cases where we see that discretion and then follow up with enforcement, the executive director and staff to let them know, whether the pattern of the use of discretion is consistent or inconsistent with the intent of the commission. And the public can do that as well because all of these cases are posted as part of our executive report. So I just want to make sure we're transparent as to all these levels of review, and it sounds like we are.
That is absolutely correct.
Okay. And Commissioner Ortiz?
I want to explain why I ask about how many exclusion is because if you have too many, it defeats the purpose of having the streamline and the education programs. So that's what I was getting at.
Yes, and because we're at pre-notice right now, you are, and all the commissioners are welcome also to suggest if they think that, a particular exclusion that's already written into the regulations that we're not touching should be amended, removed, or if there's any others you think should be included. This is all up for discussion right now. Building on what you were discussing about information that goes in the stipulation, I want to skip ahead to that issue, just because I think it's a more natural place to discuss it here. One of the changes that we're proposing to make to these regulations does involve specifying what information needs to be included in a streamline stipulation. The regulations as they're written right now don't really address this issue at all. The only thing they do is they contrast a streamlined stipulation with a mainline stipulation, and they say that a mainline stipulation must include, quote, a full description of the violation and surrounding events. Now, this implies that a streamlined stipulation doesn't have to do this, but the regulation doesn't go on to say what the streamlined stipulation should include instead. So that's what we're proposing to do via our proposed amendment here. Right now, enforcement's practice is to include a table in streamlined stipulations, giving basic information about the respondent, as well as specifying a list of the violations that are being resolved. Like, for example, in an SCI non-reporter case, there will be a list of all the sources of income that the respondent didn't report. But none of this is technically required by the regulation. So we're trying to address that by adding this language in front of you. It says, quote, a stipulation for a streamlined penalty need not include a full description of the violations and surrounding events, but it shall include sufficient information to identify the specific violations being charged and demonstrate why a streamlined penalty is appropriate under the terms of this regulation. And of course, we could add other things to this as well, such as if discretion was used in this case, that should also be reported on the settlement.
Okay, and again, to clarify, because Commissioner Wilson was out of the room, I want to make sure that that is stated in the streamline settlement. I don't know if we recommend doing that via regulation or we recommend doing that via policy. However, you think it's whatever's the best approach, I'm okay with that. Perhaps when we come back for adoption, You could have a couple different options for us with recommendations. Any comments from commissioners on that point? Okay, I just wanted to be clear to the public and to us and staff whether discretion is being used.
Can I jump
Yeah.
in real quick on a
Mr.
different
Bainbridge.
issue for Commissioner Ortiz? To give you some perspective into your concern about too many cases being filtered out of the streamlined process, our intent is not to make significant changes to what the criteria is in terms of exclusions. So assuming we don't change that much with the proposed regulations, last year, it looks like about 75% of the enforcement penalties were done through the streamlined process. So currently, it obviously, when 3/4 of the cases actually go through streamline as opposed to mainline, I think it does actually capture quite a few of the cases. So I don't think it's a concern that our movement of the exclusionary criteria is going to significantly change that amount.
So the 4th out of 5 procedural changes that we are proposing to make to these regulations deals with the circumstances under which respondents need to correct the underlying violation before they can resolve their case. We call this coming into compliance. Usually this involves filing campaign reports that weren't filed, filing SEIs that weren't filed, returning gifts over the limit, things like that. Right now, the regulations don't say anything about the requirement to come into compliance under the general eligibility requirements. It's just silent on that. If you go down to the parts dealing with individual violations, you might find, for many of them, sections saying a respondent shall file their outstanding campaign finance, I'm paraphrasing here, a respondent shall file their outstanding campaign finance forms unless the information has been reported somewhere else. What we are proposing to do is a couple things. First of all, even the sections of the regulations that do speak to this issue, they don't provide a timeline for when this needs to be done. So what we are proposing to do is, first of all, provide such a timeline, but also to simplify the regulations. We're going to not have multiple parts of the regulation under each violation saying what people have to do. We're going to take all that and just put one section under the general eligibility criteria saying what's in front of you here on this slide. It's going to say, quote, respondents must correct the underlying violations by coming into compliance with the requirements of the Act prior to completing prep or executing a streamlined stipulation. The Chief of Enforcement has discretion to waive this requirement where A, the violation relates to unreported information and the FPPC determines that the information has been sufficiently disclosed in the stipulation or other public filings. This part is already in the regulations as written under the campaign finance sections. These next 3 sections are new, but they're meant to accommodate some of the very common scenarios that enforcement has encountered. B, one of the respondents is a committee, and the committee is being or has been administratively terminated. C, failure to come into compliance would likely result in minimal public harm. Or D, other circumstances do not make it feasible for the respondents to come into compliance.
Commissioner Ortiz?
Other circumstances, that's kind of open-ended. So how do you apply those circumstances?
Well, it is meant to be a bit open-ended to kind of capture the kind of very different factual scenarios that can come up. Like, for example, say you have a case involving failure to file campaign finance forms. And it's been a few years since the campaign. Sometimes the campaigns don't have their records anymore that allow them to complete those forms. So under this regulation, under Section D, that might be some of the other circumstances that don't make it feasible to come into compliance. But this would really be the kind of thing that enforcement would work out kind of internally, like what sort of circumstances do rise to the level of being able to waive compliance or not.
So is other circumstances discretionary?
It is meant to be discretionary, yes, because it says the Chief of Enforcement has discretion to waive this requirement where.
Okay.
But again, if there are ways that the commission would prefer that we retool this language, we can. We're very open to hearing that. Okay. All right, and then the last procedural issue that we're dealing with in these proposed amendments deals with some confusion that's arisen over the separate process for issuing warning letters. Now, the Commission's ability to issue warning letters long predates the Streamline and PrEP programs. Warning letters are issued in, I would say, the lowest of the low cases where public harm is minimal, and it's somebody's first time violating that particular section of the Act. Enforcement can use its general authority to issue warning letters in situations like that. When we drafted these Streamline and PrEP regulations, we included some criteria for issuing warning letters in the cases involving the violation types that are included in these regs. Essentially, it was duplicating a process that already existed and adding additional steps and criteria that didn't exist before. So what we're proposing to do is take those back out of the regulation to avoid the confusion that can arise over which process to follow. This also has the side benefit of making these regulations that are particular to Streamline and PrEP much easier to follow, because the bulk of the redlining that you're seeing in the draft in front of you is just us removing this warning letter process that already existed under enforcement's other powers. So our proposed amendment, first of all, it makes clear that the process for issuing warning letters and the process for PrEP and Streamline agreements are two separate things. So we've added this language, or we propose to add this language, which says nothing in this regulation shall limit the authority of the Chief of Enforcement to issue a warning letter where a violation of the Act is found, but the seriousness of the offense is low, public harm is minimal, or other mitigating circumstances are present such that a monetary fine is not warranted. It's kind of a long way of saying warning letter is still an option in these cases if the chief feels it's appropriate. And then one sort of practical issue that we want to address is getting in the weeds a bit, but oftentimes when enforcement is resolving a low-level case, there will be some counts that they think are appropriate for warning letter, other counts that are appropriate for Streamline. They'll bring the case together. What they usually do is on the Streamline settlement, they'll list the counts that are getting a Streamline penalty, and they'll list the counts that are getting a warning letter. What we are proposing to do is add language to this regulation saying that that document, that stipulation, is the warning letter, so that enforcement doesn't have to then separately go about issuing warning letters, so that it, first of all, it saves staff time so they don't have to go through two processes, but it also keeps the information about the resolution in one place, in one document, so it makes it easier for enforcement to go back and check later on if a respondent has a prior, because a warning letter is considered to be a prior violation. So we're adding the language, or proposing to add the language that you see in front of you saying that a Streamline stipulation may identify counts for which the respondent is receiving a warning letter in lieu of participation in PrEP or receipt of a Streamline penalty. Such a stipulation shall have the same legal effect as a warning letter for purposes of determining whether a respondent qualifies for PrEP or Streamline in the future.
And Mr. Russell, what's the current process for that?
The current process, I believe, is that enforcement's practice is to list if there are counts for which the respondent is receiving a warning letter, they will list that in the stipulation. But they may also have to separately then issue a actual warning letter instead of just relying on the stipulation that the respondent already has.
Okay, so this makes it clearer for enforcement, like you said, when they're looking up priors.
Correct.
For their cases.
Correct.
Okay. I would flag for our IT team this issue, just so they can vet it before we adopt the regulation, to make sure that they're comfortable with the approach we're taking here.
Okay.
So that if someone runs a search, whether it's internal or external, looking for these specific documents, that they're going to be able to identify them.
Okay.
I don't suspect there's going to be an issue, but might as well, take a belt and suspenders approach.
Thank you, that's a good idea. And then coming around towards the end, I just want to address some of the substantive changes that we are proposing to the, sorry, did you have a?
No.
Okay. To the eligibility criteria that are already found in these regulations. These are mostly meant to harmonize these regulations with changes that may have occurred in other laws, like, for example, Section 84-308 was updated recently, so we need to update these regulations, the section of the regulations that deal with Section 84-308 to harmonize with that. And there are a few tweaks that enforcement has said they want to make based on their experience applying these. So just to run through these quickly, we're proposing to add additional mitigating factors for inclusion of late 24-hour reports. We are proposing to decrease the eligibility thresholds for cash contribution violations. In other words, we're decreasing the amount of cash a campaign can receive and still be eligible for PrEP or Streamline. As I said, we want to harmonize the terms of these regulations with the terms of Section 84308 that were recently amended. We want to eliminate the exclusion for Tier 2 streamline in lobbying cases where multiple lobbying reports are not filed, because this is a common situation that comes up. We're proposing to include gift limit violations where the filer has returned the gift unused or reimbursed the overage prior to the reporting deadline. We want to harmonize the sections of these regulations that deal with behested payment cases to be the same as the information that's required to be disclosed on a Form 803. And we want to adjust the penalty range for Tier 1 recurring contribution violations.
And these recommendations are being provided based on our review of the prior PrEP streamline cases, as well as feedback from enforcement. And then we reached out to the regulated community as well, and they provided us with feedback.
Correct. We reached out to the CPAA and the Political Treasurers Association, and they provided us with feedback as well.
Excellent. Ex parte to disclose here, so I forwarded along these regulations to Jay Carson and Casey Jenkins, who are on the enforcement and regulatory committees for CPAA. It sounds like they will be providing us potentially with additional comment on the regulations.
Okay, thank you.
I have a last question.
Commissioner Ortiz?
Sorry. Adjust the penalty range for Tier 1 recurrent contribution violations. Are those violations, do you take into account whether they're intentional or negligent if it's recurring?
Yes, if it's an intentional violation, it doesn't qualify for streamline or PrEP at all. That's under the general eligibility criteria. And that brings us to the end of the presentation. So in sum, I would say that we believe that the proposals that we're making today will help to clarify some areas of these laws that are a bit unclear right now. In general, they will help to simplify and make these regulations easier to apply. We are still at the pre-notice stage, so we welcome any feedback that you have on these proposals, and of course from the regulated community and the public as well. And I'm here to answer any questions you might have about these proposals.
Excellent. So the plan right now would be for this to come back for adoption in
August.
September? August?
August.
Okay, to come back for August. Okay, excellent. Well, in the meantime, if enforcement or anybody else at the commission has any additional feedback on these regulations based on their experience interpreting them and applying them, analyzing them, we're open and encourage that feedback. Same story with the regulated community commissioners. Commissioner Wilson?
Yes, Councilor Russell, excellent presentation. And I think just over time at some point, and even as an internal document, to have historical record on how we got to this point in terms of the various changes that were made to the streamlining program, and then how it started under the former Chief of Enforcement, now our Executive Director, Galena West. So, I mean, we've had a number of presentations, a number of documents out there, but 5-10 years down the road, if somebody wants to say, well, what's the historical evolution, if you will, of the streamlining program? I won't be here, but many of you will be. You can look at that document and see kind of how it's evolved over time.
Yes, I can certainly provide that background when we come back in August.
Right. And I already have a lot of that from prior presentations. I just, in moving forward, that'd be helpful.
Okay, thank you.
Commissioner Ortiz?
What do we do now? Do we express dissatisfaction?
Whatever feedback you have at this juncture in terms of how you'd like this regulation to come out for adoption.
Oh,
They're going to bring it back in 2 months.
okay.
So
So
if there's any feedback you feel like
No, I'm
there's
fine
additional
with
exclusions to add or
the
to
proposed
take out.
amendments, the only thing I remain concerned is other circumstances. It's too vague.
So I took a look at that too, and what I thought was interesting is, do we see any circumstance, Mr. Russell, do you mind going back to that slide that talks about that?
There we go.
Okay, do we see any circumstance where D here wouldn't be covered by one of the other criteria here. So we have above D, we have C, failure to come into compliance would result in minimal public harm. I was thinking, I would think that most things that fall under D, if Enforcement Chief Bonebreak would like to come up and give us her feedback, I would think that most things that fall under D would also fall under C. And ultimately, for me, what makes me more comfortable, most comfortable with that term, minimal public harm, is that something that we're laying out for Enforcement Division. You know, we come to the meetings, we lay out what we feel like is high public harm, low public harm. So you have a better idea of how to interpret this regulation versus what Commissioner Ortiz pointed out, which is just other circumstances, which you don't have as much guidance on. So I don't know if you can speak to that. If you do feel like there's that overlap there, that would make D superfluous. You can go ahead.
So generally speaking, I would agree that in the vast majority of cases, it is going to be overlapping. However, in my 10 months here, no matter how prepared you are, there's always a circumstance that doesn't quite fit. And so D just allows us in those unique circumstances to move forward with another option. I don't see using it often. It's just something sometimes we can't predict.
Okay. What do you think about this, Commissioner Ortiz? I'm interested in what your thoughts are. What if the Legal Division, Enforcement Division came with examples of the sorts of situations that would fall under this category? And then we can make a determination as to whether we feel like it's appropriate to provide this level of discretion, or we want to leave it at just ABC.
Yeah, I mean, I'm not trying to be nitty-gritty and thing, but it's just those vague words always gives me concern because you can stretch it or whatever.
Yeah, and that's understandable, and we're happy to come with a couple of
Thank you.
examples.
Yes. Otherwise, I'm fine with the rest of the amendment.
Excellent. So we could have that on adoption. Like we talked about a few times, the process for disclosure of discretion is important. Any additional feedback from commissioners? Okay. Do we have any public comment on this item? We do. Okay. Go ahead. Good morning.
Hello, can you hear me?
Yes, we can hear you. Good morning.
Morning. Good morning, Commissioners and Sheriff Silver. Rory McNair on agenda item 11. The amended exclusion bars a respondent if evidence shows they gave the FPDC false or altered evidence. This only works if the division obtains that evidence, which the draft does not require. I filed 2 sworn complaints in 2025, both now closed. The Form 700s I received were not original filings. Some were scanned after I filed. Others had their identifying data stripped. None carried the e-signature the regulations require. The principal auditor at one of these agencies I filed against confirmed in writing that every e-filing has a filing ID and a locked submission time. Files that same agency produced had neither, and neither closure letter mentioned server record that would settle it. When I sent this in, I was told to file a new complaint, which would receive a new number. I do not see how that reaches a matter already closed. A related, also closed complaint I filed in 2025 involves more than $40 million in public funds wired to an out-of-state company whose board includes the same officials. This is detailed in my June 16th letter submitted for the record. I ask here that you read it. Thank you.
Thank you. And whatever additional background comment that you'd like to share, I'd direct that to the legal division. I think that'd be helpful as we continue to pursue this regulation. And also, if there's any questions regarding the Form 700, I'd recommend reaching out to either our executive director, Galena West, or our chief of admin, Ju Wang. They can answer questions in terms of securing copies of Form 700s, either electronically or in hard copy. Thank you. Any additional public comment? Okay, excellent. Well, thank you, Mr. Russell. Excellent presentation. Great job, Legal Division, putting this together. Thank you, Ms. Bonebreak.
Thank you.
Okay, let's move on to item 12, and that's going to be pre-notice discussion of proposed amendments to Regulation 18723.1 to clarify SEI filing requirements for public officials with multiple positions. We have Senior Commission Counsel Joanna Jin. Good morning.
Good morning, Mr. Chair and Commissioners. I'm here today to present on the proposed amendments to statements of economic interest for public officials with multiple positions. And there is a presentation, so I'll wait for that to come up.
Okay, we have it right here. Thank you.
The proposed amendments to Regulation 18723.1 would do several things. It would clarify that filers who must file pursuant to Government Code Section 87200 do not need to list positions that they also hold under an agency's conflict of interest code on their expanded statements when the geographical jurisdiction of the code agency is the same or wholly included within the agency of the 87200 agency. It would also specify that elected state officers only have to file a statement of economic interest for their state elected position and that they need not list any additional positions. And the regulations would also make clarifying changes. So what is an expanded statement of economic interests or expanded statement? It is a single SEI that a public official who holds multiple positions subject to reporting requirements under the Political Reform Act can file instead of filing separate SEIs for each position. An expanded statement must disclose all reportable interests for all jurisdictions and list all positions for which it is filed. And I have an example of an expanded statement here. On a SEI, right under the name in Section 1, an official will list their position as well as their agency. If the official also has reportable financial interests, the official will provide that information under Section 4, which you cannot see on here because it's actually cut off, but they will disclose their investments, real property, income, loans, business positions, gifts, travel payments, and the like. If they also have if they are an 87200 position, they'll also report on any prospective employment as well. When that official has more than one reportable position, the official must also file a separate statement of economic interest for that other position. And that the personal financial interest for that other position may differ depending on the geography of that jurisdiction, as well as what has to be disclosed for that position specifically. However, the existing Regulation 18723.1 allows a filer to file just one consolidated SEI, listing all the positions and listing all reportable interests for all the positions. So on an expanded statement, there's an opportunity to add those additional positions. In Section 1, you can see that there's an opportunity to add an attachment. And the position then in Section 1 becomes known as the primary position. And the additional positions are what is listed in the attachment. The expanded statement is filed with all agencies for all the positions that are listed on the expanded statement. So in this example, the SCI would be filed with both the county that's listed in the primary position, as well as the city, which is listed in the additional, as an additional position on the attachment. Expanded statements are entirely optional. It's for the convenience of the filer. If the filer still wants to file separate statements for each position, they can certainly do so. Okay, so what is a
So quick question for you. If you could go
Certainly.
back to the previous slide.
Absolutely.
Great, thank you. Okay, so if someone's filing an expanded statement here, they're gonna be disclosing all their reportable interests for both of these positions. So they have their supervisor position where they're a 87-200 filer. So
Correct.
they're one of the specific positions that are enumerated in statute as having to have this level of disclosure. And they're also disclosing as a code filer. Is that right? The city manager code filer?
The city manager is an 87-200
Okay, so
position.
they're an 87-200 filer as well. So what they're doing here is they're doing full 87-200 disclosure for their interests in County of Placer and their interests in the city of Sacramento. That's what this form, this expanded Form 700 is gonna include.
That is correct. Because there's the broadest disclosure, all reportable interests under 87-200, the difference would really be in the jurisdiction in this case. And so, for example, if there are any real property or business interests that are listed in the county and the city, those now both need to be included.
Okay, so if there's an interest that's in Placer County, but it's not in city of Sacramento, they're still gonna have to disclose it on the statement.
That is
And
correct.
vice versa.
Yes,
Okay, that's helpful. Thank you. You can proceed.
thank you.
Oh, go ahead, Commissioner Ortiz.
You just make copy of, and then send it to the city.
Yes,
Okay, you don't have to do brand new, type the original or anything like that, just a copy.
yes, it's essentially like a one-stop shop document that you can use for both agencies.
But to clarify, these would both be filed with us, is that correct? Because they're 87-200 filers?
Yes.
Okay,
Yes, for all 87-200 positions, they would be filed with the commission pursuant to section 87-500.
okay, excellent. Sorry for getting ahead of you. This is a really
Oh, no,
complex
that's
topic. I
great
want to make sure I'm asking
questions.
all the questions that I have. Excellent. You can, Commissioner Ortiz, do you have additional questions or? Okay, you can proceed.
Thank you. Okay, so what is a primary position? A primary position is determined by Regulation 18723.1A2. If an official has multiple positions specified under 87-200, as Mr. Chair just mentioned, the primary position will be the one with the elected office. If neither position is an elected position, then the position with the agency that requires the broadest disclosure will be the primary position. In a different scenario, if an official holds one 87-200 position and at least one code-designated position, then the primary position will be the 87-200 position. And lastly, if the official holds multiple co-designated positions, the primary position will be the position that requires the broadest disclosure.
This is kind
Commissioner
of
Wilson.
a technical question, but in terms of, the primary position, who would be the filing officer? I'm assuming it would be the one connected to the primary position. If the form is filed late or there's a technical problem, who would, currently there's a filing officer that interacts with each elected official or staff person. Who would be the primary filing officer that would be responsible to make sure that everything was submitted in a timely fashion?
So the filing officer with each agency would still need to contact the official to ensure that they timely report and file for each of their respective
Oh,
agencies.
Okay, that makes sense. Okay, thank you.
Thank you. I have a chart here of the 87-200 positions in case that's helpful. They're primarily for the state elected state officers and several state entities, including the commission. And there are also local decision makers too as well, both for the county and city. So that would include the governing bodies, the administrators, council, treasurers, and as well as the planning commission, since they make land use decisions. In addition, the other positions would be the public officials who manage public investments, as well as judges, court commissioners, and candidates to any of the 87-200 positions that are listed on this chart. I also wanted to mention that, Mr. Chair, in the example that we had with the expanded statement, if a person must file with the FPPC for more than one position. They only have to file once. They don't have to file multiple times. For the approach, as to how to determine how to complete an expanded statement, there are a few questions that I have before you. Does a person hold more than one agency position? Are the positions reportable? Is the person an elected officer, an elected state officer? If they are, they actually only need to file and list just for that elected position. Is there an 87-200 position? Is there a code-designated position? And if so, is the other position an 87-200 position or a code position? And what is the jurisdiction of that code agency compared to the jurisdiction of the other position that is listed? And I have some examples too. This chart here shows which agency an official will file with and what their reporting obligations are for an expanded statement, as well as which primary position will be listed for each of these different scenarios. To simplify everything, I've only included 2 positions here. So for the first row, if both positions are 87-200 positions, the filing agency, as we discussed, is a commission. Both positions will be listed unless they are an elected state officer under the proposed amendments, which in case that elected state officer will only list that position.
Could you repeat that again, please?
Sure. So if someone is an elected state officer, such as like the lieutenant governor or a legislator, they only have to list their elected office. They don't have to report on any other additional positions that they may hold, whether that's an 87-200 position or a code position. And that's under the proposed amendments.
And this only applies to elected state officers.
That is
What
correct.
happened about local elected people? Because you had an example of a board of supervisor before.
Correct. It would depend on what the other position is. So an elected local official will be an 87-200 position. And I'll get into an example that I think will help clarify anything.
yeah.
But in some instances, they may have to report on the other position. In other instances, they may not. It'll be very fact specific.
Is this trying to help state elected officials or everybody else?
Well, the changes to the regulations would allow legislators to only have to list just their elected position. It would not apply to locals in that change. But I think I have an example too that will illustrate that. So continuing on here, the primary position for that first row will be the elected position, and if neither are elected, then it is the broadest disclosure. In row 2, if one position is an 87-200 position and the other position is a code position, and the jurisdiction of that code agency is the same or wholly contained within the 87-200 agency, the filing agency is going to be just the FPPC, and they only have to report for the 87-200 position. In the third row, if the first position is an 87-200 position, and again, we have another code position, but the jurisdiction is larger than the 87-200 agency, then the filing agencies are both FPPC and the code agency. Both positions have to be listed, and the primary position will be the 87-200 position. In the fourth row, if both positions are code-designated positions, the filer files with both agencies generally, and both positions are listed, and the primary position will be the broadest disclosure. And lastly, in the fifth row, if both positions are code positions, but the second position has a jurisdiction that is the same or wholly included in the, as compared to the other code position, disclosure is the same as section 87-200, which is the broadest disclosure required. and the filing officer is the same as the other agency, then the filing agency is only the code agency for the first position. And you only have to report for the first position. And so I'm going to go through.
Commissioner Wilson?
Yes, Commissioner.
So your explanation was very detailed and very
you.
clear. And just a hypothetical situation, let's say you had an elected official and they had someone who's been doing their helping them fill out their paperwork, staff person for years.
Mhm.
And they say, you know what, I just want to continue to just fill out all the forms for each of the positions as I've done in the past. Would they have that option, or would they be obligated to just file as an 87-200 filer in accordance with the new guidelines once they're adopted?
They are always more than welcome to provide more information than is required. I
Okay.
think the concern is more that they don't provide it or they don't file at all.
Okay, all right.
Yep.
Okay, thank you.
Thank you. And I will go through a few examples as well.
Excellent. And of these categories, what would you say is the most common? I would think someone with multiple 87-200 positions is relatively uncommon.
Right.
In my experience, I would say of these, I would suspect 87-200 filer who also is a code filer is probably the most common of these. If you don't have that exact data, that's fine. I just was interested in whether we had that.
I agree. And I don't think that 87-200 positions or 7-200 positions are common because it would be compatible. You wouldn't have someone who holds an elected state office as well as another elected position on the local level. There are a few circumstances in which some of the state elected officials will also hold appointments that are 87-200 positions. And likewise, in the example that I provided, if you're in a potentially in an employee capacity in one jurisdiction, that's an 87-200 position. You could also have another 87-200 position too, where it's elected in a different jurisdiction.
Okay.
But I agree, 87-200 and code positions are most likely the scenario you'll see.
Okay, that's helpful. Thank you.
Thank you. Okay, as a first example, the lieutenant governor serves on various state boards and commissions. Which agency does the lieutenant governor file the SEI with? And that will be the FPPC. The lieutenant governor only needs to file for the lieutenant governor position, and the proposed amendments do not change this rule. Under the existing regulation, the lieutenant governor only needs to file for their position. Absent that provision, she would have to file for the other 87-200 positions which she holds, which would be the California Coastal Commission. So again, it does not change the proposed amendments do not change this, it's the status quo. Here's another example. A state senator is running for city council. Which agency does the senator file the SEI with? And it would be the FPPC. Both are 87-200 positions. As I mentioned, if someone's running as a candidate for an 87-200 position, that itself is an 87-200 position. So an expanded statement can be filed. Under the existing regulation, the Senate position would be the primary position because that's the elected position, and the city council candidate position would be listed as an additional position. Under the proposed amendments, the senator would not be required to list the additional positions because an elected state officer would not have to list any other additional positions. The elected state officer, such as legislators, would only have to list that state elected position.
Commissioner Ortiz?
Thank you. What is the rationale behind that?
That's a great question. When the regulations were adopted in 2020 by this commission, the rationale for to applying the rule to statewide elected officers was to just streamline everything. By virtue of their positions, they also are appointed to other boards and commissions and hold other positions, many which are you can find easily through web search. And so that was the rationale for that. It is likely that that was intended to apply to elected state officers. Interestingly, statewide elected officers do not include legislators. And so this would be to clean that up.
The purpose of an SEI is to prevent conflicts and vote and everything like that. So how does the state senator who's running for city council, well, you know, how does he or she fulfills that when he only one filing?
That's great. It's a great question. So for the state offices, their jurisdiction for which they have to report all their financial interests for is the entire state. So even if they are running for a city council position, that jurisdiction is going to be smaller. So by just having to simply disclose all their personal financial interests for their state position, with the 87-200 disclosure being the broadest disclosure possible, you're going to have it all thrown out there because they're in a state office.
Okay.
And there's the questions. Okay. Okay, and here is an example. If a LA County supervisor is a code filer for the LA City's Board of Harbor Commissioners, which agency does the official file the SEI with? And that would be the FPPC and only for the county position. As I mentioned on my second slide, 87-200 filers that also have a code position where that jurisdiction is the same or smaller than the 87-200 agency only has to file for the 87-200 position. So in this case, the county supervisor is an 87-200 position. So on the screen, that'll be the area highlighted in blue, and the LA City code position is highlighted in orange. And so that jurisdiction is smaller than the 87-200 position. So based upon that, the official only has to file with the FPPC because it's an 87-200 position, and that's it. And so this regulation, these proposed amendments would not change that. This is just the status quo.
So we're just codifying the advice that we've already provided as an agency as to what to do in these circumstances. Is that correct?
That is correct. And that is also language that's contained in the model regulations under 18730 that agencies adopt in their conflict of interest code.
Okay, it seems to me ultimately the policy purpose here is that we're signaling to the public that we are the agency, we're the source that they should be going to if they want to see economic interests that are disclosed by the highest level policymakers across the state of California, basically. It's kind of consistent with the legislation we've pursued related to transferring filing officials, the relevant filing official from the local level for these high level officials to the FPPC.
Yes, and with recent legislation too, all the 87-200 filings are on the commission's website. And if someone searches their name, it'll pop up and they could simply download it as well.
Okay, that's helpful. Thank you.
Thank you. Okay, here's another example. If a LA City Council member is also a code filer for the LA County Civil Service Commission, which agency does the official file with? And that will be both the FPPC and LA County. An expanded statement can be filed listing the city position as a primary position and the county as an additional position. We're applying the same rule as the previous slide, But now the 87-200 position, which is the city council position, is the smaller jurisdiction that's in orange, and the code filing position is a larger jurisdiction in blue. And as we previously mentioned, that means that any interest in real property or business interests might need to be additionally reported. So that's why you have the change here. And again, the proposed amendments do not make any changes. This is the status quo. We'd simply be making that clarifying update. Okay, and here's the last example that I have. If a person is both a code filer as a LA County planner and a LA City Board of Harbor Commissioner, which agency does the official file with? And that'll be both the county and the city. The filer can file an expanded statement or separate statements if they want to. If an expanded statement is filed, the filer would list the position with the broadest disclosure as the primary position and the other position as an additional position. And to determine which one has the broadest disclosure, you would have to look at each agency's conflict of interest code. Again, this is the status quo, and the proposed amendments simply clarify this. And so just to summarize, out of the 4 examples that I mentioned, out of the 5 examples I mentioned, 4 are the status quo and clarifying, and then there would be a change to specify that elected state officers only have to file for their elected position and need not list additional positions. And with that, that concludes my presentation. I'm happy to answer any questions that you may have. Thank you.
Thank you. Any questions from commissioners?
So that I understand, what you're doing is just codifying some regulations, some policy. Is that what you're doing for state elected officials?
Yeah, we are essentially expanding the exception to say that any, that you only have to file for the elected position to include legislators.
Okay, so every other local elected official, be city council or special district, will still follow the existing requirements.
That is correct.
Thank you.
Thank you.
So I'm interested in one scenario which would divert from what current law is. It's laid out, and I think 2 examples ago, if you could go back to that one. Let's see. I know it's got a map. Okay, I think this is this the one where we have? No, it's the one where you have a individual who's an 87-200 filer, also a code filer, but the agency that they're a code filer for has a larger jurisdiction than the 87-200. I feel like you're taking the LSAT again.
Yeah, no, this is great.
Okay, so is this the right one? Okay, so we have an LA City Council member. They're also a code filer at the county level, right? And in this circumstance, they would both have to file with us as a 87-200 filer as City Council member. And then they would also have to file with LA County. So I've spoken with filing officials and public officials all over the state, and one thing that comes up is number one, which I'm sure you'll appreciate given the substance of this regulation, is that there's a lot of confusion as to when they are going to be exempt, these 87-200 filers, when they're exempt from having to file with their other agency where they're code filer. I think this does an excellent job. The regulation right now does an excellent job of laying out under what circumstances they would not have to file the situation you laid out, where you have an 87-200 filer whose jurisdiction that they're reporting for is the same or larger than the 87-300 code filer requirement, right? What I'm interested in is this scenario where you have someone who's an LA City Council member, 87-200 filer, right? But they're also on a county commission, which is a larger jurisdiction. I'm interested in this scenario because you have folks that have expressed concern that, hey, I wish there was a possibility where I could just file one document, an expanded statement that includes all my reportable interests at the highest possible disclosure category for the largest possible jurisdiction, and then just be done filing. So I don't have to go and file with all these different jurisdictions because it causes administrative issues for city clerks. as well as the public officials, right? Without, they believe, any sort of downside in terms of transparency. So what I'd be interested in is to see if there's any solution that we could propose via regulation or perhaps a legislative proposal in the future where we could allow someone like a LA City Council member to file with us an expanded statement that discloses all of their reportable interests for LA County, right? Not just the city of LA. So that would cover anything that would be reportable for their code filer position for LA County, and also anything that would be reportable for LA City. Does that make sense? I know that's a lot. More than happy to, clarify any questions, issues you might have with that.
No, those are great comments. Just thinking about that, the code reviewing body for the county in this example will be the County Board of Supervisors, and they do a biannual review. The regulations, the model regulations under 18730 do not include such a provision. So we could look into that and also report back on that. I think the proposed amendments that you have are to make sure that the proposed amendments to regulation 18723.1, which is before you, relating to officers or officials with multiple statements, has conforming language with what is already in those model code provisions. And so another thought is, okay, if the county has already adopted their conflict of interest code based off of those model regulations, how we would go about making those changes, but we could certainly look into it and report back. Those are great comments.
So when I'm meeting with these folks for, I guess I should disclose ex parte right now, I met with the city clerk for the city of Calabasas. I've also in the past met with City of Thousand Oaks, City of Ventura, City of Los Angeles, County of Ventura, County of Los Angeles, several jurisdictions up here in Northern California as well. Those jurisdictions were not related to this specific regulation, so I'm not going to run through each one of those. The only ex parte for this would be City of Calabasas. Nonetheless, so they're, I think they would ask, can they just amend their conflict of interest code now and accept expanded statements that would satisfy this reporting obligation for this example filer here? So for example, could the Board of Supervisors for LA County, could they decide we're going to accept expanded statements? We're gonna accept expanded statements. We're gonna amend our conflict of interest code. Is there a method that they can go about doing that? Since what we're talking about here is an 87200 filer who will ultimately be filing with us. Does that make sense?
It does.
And if you don't have the answer, I think this is a great thing for us to take a closer look at and then come back when we're considering adoption. This is a very complex issue, and I also would want to get feedback from all the clerks and the filing officials and their organizations to see if this is, the evidence that I've received is whether it's anecdotal, whether it's just, a few different people who are interested in this, or their membership really feels that this is an important change that would not at all impact transparency, but would significantly cut down on kind of the administrative burden that they deal with Form 700s. So with all that, I'll throw it back to you.
Those are great points to make. I would like to look at this more. It does involve multiple regulations. I'd also like to consult with the SEI unit, and as you said, with other entities as well, and then could come back in August with that information.
Excellent. And I'm glad that you brought up the SEI unit. The other unit I would consider flagging this for is our IT unit. I wouldn't want us to adopt or allow for any sort of new process that we're not capable of handling technologically. I just wanted to throw this in there just because I've heard it from so many different individuals. They'd love to have this option. Any other comments, questions, commissioners? Is there anything left in your presentation?
No, that was it.
Okay, do we have any public comment? Excellent presentation. I think that's what, thank you. Yeah,
Thank you. Thank you.
excellent, thank you. Okay, let's move on to our legislative update. Item number 13, we're gonna have Senior FPPC Legislative Counsel, Lindsay Nakano at the desk. Good morning, Ms. Nakano.
right, good morning, Mr. Chair, Commissioners. Okay, there are 15 PRA-related bills that are still active in the legislature. I'll provide updates on the status of all of those bills, and I will go over any amendments that occurred since our last meeting. There is one new bill that was amended just last week to amend the PRA AB 1130. I'll summarize that bill later in this presentation. There's also a copy of the bill attached to today's agenda. The author's office would welcome commission support, so after any questions and discussion later on, the commission may choose to take a position.
Thank you.
All right, I'll move on to commission-sponsored bills, and I'll start with AB 1736. This is the bill that extends the existing prohibition on astroturfing or creating a fictitious appearance of public favor or disfavor about a legislative or administrative action. It extends it to apply to lobbyist employers. That bill passed in the Senate Elections Committee on consent. AB 1788 is not moving forward this year. This bill would have expanded reporting for certain nonprofit organizations that pay for elected official travel, where donors to the nonprofit accompany the elected official on that travel. As I understand it, there were outstanding issues regarding exempting organizations such as CSG and NCSL. Those were not resolved before the House of Origin deadline, and the author opted to not move that bill forward. If this proposal continues to be a priority for the commission may choose to pursue it as a proposal again next year. AB 1789, which would generally require candidates and treasurers of candidate-controlled committees to take a campaign training course with the FPPC, passed in the Senate Elections Committee on consent. The bill was amended to change the trigger for the training to require that a candidate take the training upon registering as a recipient committee, rather than upon filing the statement of intention to be a candidate. And that change was made to allow the commission to have a more certain list of which candidates would be required to take this training, since the statement of intention is filed with the SOS for state candidates and at the local level with their local elections offices. So there would be not a singular place to find all of those candidates. AB 2255 relates to enhance disclosure for large expenditures in years where the candidate will not be on the ballot, is set for hearing in the Senate Elections Committee on June 30th. AB 2421, authorizing the automatic termination of inactive committees, passed in the Senate Elections Committee on consent as well. AB 2592, yes.
Commissioner Ortiz?
Yeah, so in this one, candidate doesn't have to close that committee. It will be up to the secretary. That's good.
They are required to under law. However,
Yeah.
there are some committees that, for various reasons, have not closed, and many of them are very old. So this would enable SOS to close out those old inactive committees and have more relevant information on CalAccess.
Because right now there is a fine if you don't report, even though the committee is dormant or whatever.
Yes, technically they are in violation if they're still open and not filing. But some of these committees are so old that their contact information is no longer good. It's not possible. They're past the statute of limitations. It's not possible to contact them further.
Commissioner Wilson?
Councilman Kano, on the kind of a technical kind of question. Let's say you have a dormant committee that hasn't had any activity for, let's say, 10 years, but it has funds in that account. Does that fund, are those funds, once the committee is shut down, does it go to the general fund or does it go to unclaimed property? What happens to that? What happens to that money?
So this bill has a maximum that can be eligible, a maximum in their bank account that can be eligible for termination, $3,000 on their last reported statement. So any leftover funds are still considered campaign funds and would need to be disposed of the way that campaign funds are required to be disposed of under the PRA.
Yeah, but you had said the contact information may not be accurate, so you may not be able to find the treasurer or any of the elected officials.
I think realistically, most of these committees are so old that that money was probably disposed of a long time ago.
Okay. Okay, thanks. But you understand my question,
Yes.
right?
Okay, left off on AB 2592. This bill would transfer the lobbyist training program from the Legislative Ethics Committees to the FPPC. That bill passed in the Senate Elections Committee on consent. AB 2655, which would require any security personnel paid with campaign funds to be appropriately licensed. That bill also passed on consent in the Senate Elections Committee. SB 401, which would authorize the Commission to extend filing deadlines under the PRA in emergency situations, passed in the Assembly Elections Committee on consent. The bill was also amended to clarify that the Commission may extend a deadline only if the emergency situation is reasonably likely to affect the individual's ability to timely file. The bill was also amended to add that the filing extension may be no longer than 60 days from the date of the original deadline. And it was amended to add that the authority to extend a deadline does not include the authority to extend filing deadlines for campaign statements during the 90 days before an election. Last of the Commission-sponsored bills, SB 1389, which extends the length of time that filing officers may waive the late filing fee for Form 700s, passed in the Assembly Elections Committee on consent. Those are the sponsored bills. I'll pause here for any other questions or comments before I move on.
Commissioner Ortiz?
Yeah, I want to make a comment. I think AB 1789 is a very important bill, and I know that FPPC is a sponsor, you're gonna have to spend money, but it's so important to have treasurers or candidates to be trained because there's so much rules for, treasurers and candidates that you can easily kind of blow it. So this is very, very important. I just wanted to comment that.
I agree. Here. I mean, it's worth pointing out very quickly that this is one of the few areas that we have jurisdiction over where the folks who are subject to these laws do not have to take a training. I think it's really critical that they be required and exposed to the relevant rules so they can follow them. We don't want to have to deal with unintended violations because they just create, I think, a lack of public trust and also administrative issues for us, right, and the individuals who we believe are acting in good faith and just mistakenly violate these rules. So I'm very glad and thankful to the author, Ms. Berner, for pursuing this.
Thank you for your comments. Anything further before I move on? Okay, on to other commission-related bills. The first is the new bill I mentioned at the top of the presentation, AB 1130. The bill was amended on June 11th to delete its former contents and replace them with a proposal that would amend the PRA. It's authored by Assembly members Berman and Rubio, with Senator Umberg as principal co-author. And specifically, the bill amends the section in the PRA that requires individuals who post content online to include a disclaimer statement when they were paid by a committee to post content that supports or opposes a candidate or ballot measure. So for example, if a social media influencer is paid by a committee to post a video on Facebook that says, "I support candidate X for city council," the influencer must post a disclaimer with that video that says the author was paid by the specific committee in connection with that posting. This requirement first took effect January 1st, 2024, and under existing law, no one is liable if the person paid by the committee does not include that disclaimer that they were paid. AB 1130 addresses that by adding liability so that the person paid by the committee and the committee are both liable and can be subject to an enforcement action if the disclaimer statement is not included. And the addition of liability will allow the Enforcement Division to effectively address any violations. AB 1130 also requires that if the payment is required to be reported on the committee's campaign statement, the committee must include a statement that the payment was for a paid third-party post. So it adds some detail to what must be disclosed. And the author's office would welcome Commission support I'll pause here for any questions or discussion from the commission, and following that, the commission may consider a vote to support if it wishes.
Any questions or comments from commissioners? Personally, I'm going to suggest that we support this bill. I think it's a very important piece of legislation. This is an excellent opportunity for us to ensure that this important reporting requirement has teeth, this important disclaimer requirement has teeth, and that the public receives the context and the information that they need in order to understand what they're seeing and hearing before they go to the voting booth. I think what's important to note, though, here, and what gave me pause initially when the author's office reached out to pursue legislature for us to take a position at this juncture in the election cycle and the legislative session, is that this isn't necessarily going to change what sort of conduct is legal and illegal. It goes straight to liability. It goes straight to our ability to make sure that the public is getting the information that they need as to these specific ads, right? And it goes to accountability. So I think that's critical, because my initial concern was, well, if in the middle of an election cycle, in the middle of a legislative session, we decide that we want to characterize certain conduct that's legal right now as unethical or inappropriate, I think that might be us putting, our too much influence on an election, right? But here we're not doing that, and that's why I feel so strongly this is an excellent opportunity for us to take a strong position in support of this legislation. I want to thank Mr. Berman for approaching our office and proposing that we take a position on this, and I'm going to support it. I have a few different ex partes that I want to disclose related to this legislation. So I've discussed this legislation and shared those sentiments in terms of my considerations in deciding whether or not to support this with Sean McMorris over at California Common Cause, Good Government Group, with Bob Stern over at the LA Ethics Commission, with Nick Sanders, the Political Law Group, Elena Rodriguez with the Assembly Speaker's Office. And I sat down for several interviews. I sat down with Lynn Tott at the Southern California News Group, as well as Tyler Katzenberg at Politico to discuss in detail why I felt that this was so important. And I also had a conversation with Robin Epley at the Sacramento Bee. Excellent. Any other questions, comments? Do we have any public comment on this item before we take action? Okay. I'm going to move that the commission takes a position of support for this specific legislation. I believe it's 1130, so a motion to support AB 1130, is that correct?
Correct.
Okay, do you have a second?
A second?
Excellent. Ms. Vo?
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye. Aye.
Chair Silver?
Aye.
Motion passes.
Thank you. Anything else for Ms. Nakano before we move on to the next item? Okay. Thank you, Ms. Nakano.
I do have some more.
Okay.
Just some quick updates on the remaining bills. I'll make it fast. AB 1560, which prohibits a person from registering as a lobbyist if they have certain convictions, was set for hearing in the Senate Elections Committee June 30th. AB 2413, which would prohibit large format public advertisements that include the photo of an elected official from being paid for with public money, is awaiting referral in the Senate Rules Committee. SB 900, relating to advertisement disclosures, was amended last month to strike the change that would have required that mass mailings include the top 5 funders rather than the top 3 funders, but that was stricken, so it will remain top 3 funders. And the bill is set for hearing in Assembly elections July 1st. SB 1159, which would have excluded AI systems and related technologies from the definition of person in the PRA and other areas of law, was amended and no longer amends the PRA. That bill will be removed from any future legislation reports. And the final 2 bills passed in the Assembly Elections Committee on consent. Those are SB 1175 and SB 1432. That concludes my presentation. Thank you.
Thank you. Okay, why don't we move on to our executive staff reports. We're going to start with enforcement. Chief Bonebreak. Good afternoon.
Good afternoon now, Chair, Commissioners. My report is as submitted, but I did want to point out one aspect of that which was the pretty significant increase in complaints that we've received since our last reporting. That complaint number did go up quite dramatically, but the team is doing an excellent job at processing those and keeping those numbers down despite the increase.
Excellent. Thank you for that update. We didn't get a chance to delve too much in the consent calendar. So generally, I want to just note and thank the enforcement team for addressing some of these older cases. Senior Commission Counsel Neil Bucknell, as well as our new enforcement attorney, Kevin Cornwall, did an excellent job making sure that these cases resolved. So appreciate their hard work on those. Thank you.
As well. Thank you.
Anything else from commissioners? Okay, thank you. Okay, let's move on to our next report, and that's going to be our audit report. Good morning, Ms. Shaw.
Good afternoon, Chair and Commissioners. My report for this month is good, but happy to answer any questions.
Excellent, thank you. I don't have any questions.
No.
Okay.
Thank you.
Thank you. Legal Division, Mr. Bainbridge.
Yeah, just one educational item that isn't listed in here. We yesterday launched a new YouTube tutorial on behested payments. It's about 28 minutes long. It's the first of what we plan to have a series of YouTube videos that provide trainings that are sort of briefer than our more comprehensive trainings, and they're based on more specific topics. So thank you to Karen Harrison, Chloe Hackert, Mason Lord, and J.Y. Ranger for putting that together. The next one staff will be working on is one for the Statement of Organization, the 410. Our data shows us that the number of 410s filed spikes in, I think it's late August, early September. So we're going to have it up on our YouTube channel and then also a link on our website for people that are interested in either of these topics.
Excellent, thank you. Commissioner Wilson?
I have a question. I know I made this comment before, but I think, Council Bainbridge and the team that's working with you on educating the public, educating filers and various staff is very beneficial. This is kind of just a general question. Let's say someone has taken the training and they've been very diligent, but then they end up having to come before enforcement because of some potential violation. Is it taken into account that they actually took training in the past? Is that beneficial if they end up having an action filed by with the FPPC?
I'm hesitant to speak how enforcement would treat that sort of situation.
Yeah, it's a hypothetical. I'm just kind of.
I'm not sure.
Okay.
Let me think about that. I know we would if they thought twice, but I don't know that I've ever completed the training.
Right. Yeah, because they could have completed the training and then violated all the regulations in the process. So I was just kind of curious. Yeah, you don't have to do any more research, but thank you.
Okay, thank you, Mr. Bainbridge. Dr. Ju Wang, Chief Administration, presenting the Administration and Technology Division report. Good afternoon, Dr. Wang.
Good afternoon, chairs and commissioners. My report will submit as it is. Just one thing I want to point out. So now it's end of the filing season. So we review the statements submitted by filer explaining why their Form 700 file was late. So technical issue was the most common explanation. So we have 39%. Filer report, they have some technical issue, which include the password reset, have some difficult to upload Excel template, and confusion about the new e-filing system, especially since we have almost 6,000 new filers this year. So, of course, we see many filers have the health and family emergency, as well as the heavy workload and competing the job responsibility. And some filer just misunderstood their requirements. So now we see all this barrier. So we will commit to improve the process next season, and we will continue to improve our e-filing system. That's all.
Excellent. And if you wouldn't mind at a subsequent meeting, bringing back up the issue of technical issues causing late filings.
Sure.
Specifically, it'd be great to hear from you and the IT division as to what changes we might be able to make to address that issue?
Yes, definitely. We're going to, since now we know all the issue, maybe we can have kind of a list how we're going to address.
Yeah,
next
because
week.
so right now, so it sounds like we have a lot of issues with folks who forget their password. So
Correct.
can a filer just hit a button and create a new password or no?
Yeah, and sometimes it is kind of tricky. You need to really copy paste, not really just type it, because sometimes the filer just try to type temporary password and it's not working. And sometimes they got the email and they didn't really process temporary password at the certain period, and temporary password already expired. So it's very easy, frustrating.
Okay, excellent. Well, I'm looking forward to hearing what IT thinks we might be able to do to get those numbers down in terms of late filings.
Definitely, that's good to go.
Thanks so much.
Mm.
Any other feedback from commissioners? No? Okay, throw it over to our executive director, Galena West.
Hello, nothing to report this month, except I watched the Behested payment video on YouTube and I thought it was terrific. So I encourage everyone to take 28 minutes and give it a go.
Excellent, thank you. Okay, let's move on to, well, is there any public comment on any executive staff reports? Hearing and seeing none, let's move on to commissioner comments and proposed future agenda items. Do we have any from commissioners? Okay, then I'm gonna go ahead and move to adjourn. Do you have a second?
No, second.
Excellent, Ms. Vo?
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Chair Silver?
Aye.
Meeting adjourned.
Gotta work on the trigger finger. Yeah.